which is different from what you're saying. So what were you saying in your introduction? Whatever you said is different from what you've read now. Do they sound the same? What did you say now? Now repeat what you said and confirm whether those two things are the same.
I said that a controlled tenancy shouldn't be in the agreement should not contain a clause for breach of covenant.
Is that what you've read? So what is your question? Ask the question.
Now, because of the way I'm understanding it, that's why I think maybe there's a variance in the way what I'm seeing as grounds for termination for the controlled tenancy by the landlord.
What did we say about that specific point? What did you say about somebody answer that question? What did you say about the question on provision for termination? What did you say? Guys, what did we say? Somebody, what did we say about that? Yes, Sergey?
On controlled tenancies, what we said about it is that one of the characteristics would be, in the event that it has been reduced into writing, one of the provisions would be termination that is additional to in the event of breach of covenant, meaning it would have two different terms for termination. There would be termination on its own as well as termination in the event of breach of contract.
That is close to what I said. That is close to what I said. Can you mute that microphone of yours? Somebody's hand is up. Jennifer, Tiana?
Okay, then maybe that answers that one. I think I understood it differently. Okay, and then if you'd allow me to please take you way back.
So what is your question answered?
Yes, it is. It is. Thank you.
What is the answer to the question that you asked?
The question was, if at all it's not supposed to contain a breach of covenant, then how come that one of the grounds for termination of that agreement controlled is where there's a breach of covenant? So that's where the variance was, but I've understood
What have you
what
understood
Anyanza
now?
has explained.
I'm asking you what is the answer to your question.
It means that a breach of covenant.
You just said you understood. What have you understood? Now tell us what you've understood.
I'm on the spot. Okay.
What have you understood? Tell us. I've just asked you guys. Have you understood? Is your question answered? Yes, it is answered. Now tell us what the answer to your question. Which is?
From what Anyanza has said, I understand. I get that it doesn't mean that a breach of covenant should not be one of the many provisions in the agreement. So if at all it means it should be contained in the agreement, then it would answer my question for why then we have that as one of the grounds for termination.
Okay. All right, so
Yeah.
let me answer your question. So the question, the issue is when it comes to the question of termination, guys, I said that breach of contract is an obvious, okay? When a contract is breached, that is an obvious ground for termination, okay? If a contract or a tenancy agreement is violated, any covenant in the tenancy agreement is violated, then that is a ground enough to terminate the lease. Okay, that is a ground enough to terminate the tenancy. However, sometimes the tenancy agreement can also have a clause saying that you can terminate this contract by maybe giving a notice. For instance, when you give a notice, now that termination has nothing to do with breach of any covenant. So in that instance where it has a clause for termination, otherwise, or a clause that is not dependent on a breach, then that becomes a control tenancy. So anytime the contract or the tenancy agreement allows you, anytime the tenancy agreement allows you to terminate a contract without any breach of contract, then that is a question to do with control tenancies. That is what I say. Okay, so breach of contract or breach of any covenant is an obvious reason for termination, but you can also have that contract can be terminated by any other way aside from breach. And we are not saying, Nyanzwa, we are not saying that it will have two clauses. Okay, we are not saying that it will have two clauses. We're simply saying that the question on termination on a violation, it doesn't have to be in that contract. It is an obvious reason. You don't have to have it in the contract that a contract or a tenancy agreement shall be terminated if you breach. No, it doesn't have to be there. It is an obvious reason. When you terminate, you go. Okay. Now, because of that, you need to understand that certain landlords and certain tenants may get into an arrangement where they indicate that you might be able to terminate the contract at any time before of the completion of the term, or for any other reason. For instance, that is an example that I gave, that this contract can be terminated by the other party giving notice to the other party. You get what I'm saying?
Okay. Yes, it's much clearer now. Thank you.
Have you understood what I said?
Yeah, now I'm much clearer. Thank you.
Have you understood what I said?
Yes, I have, Mwalimu.
Okay, that's perfect.
Yes.
You have another question?
Yes, I do. But this one is way back kwa due diligence.
I don't know whether we'll go back to due diligence now, but ask, let's see.
Okay. I listened to the class again, and there was a point you said during the point of deduction, if there are questions that the purchaser has and the vendor doesn't have satisfactory answers to, one of the options for the purchaser is to rescind the contract. And so this, why I'm getting a bit confused is because from my understanding, the deduction stage comes before the execution of the agreement. So how come then the rescission of this particular agreement is one of the remedies for the purchaser?
I taught this question, Jennifer, and I said there are two types of due diligence. We have the pre-contractual and the contractual due diligence. There's due diligence that is done after the contract is signed, and there are two, the deduction of title and requisitions. Investigation of title happens after the contract is signed. Deductions happen after the contract is signed, and then requisitions. Searches and pre-contract inquiries, like the the site visit, those ones happens before the contract is signed. I gave the difference between the two. We have 4 issues in terms of due diligence. 2 of them will come early, and then 2 of them will come after the contract. I say that. Remember that?
Okay. That's where the confusion was. Thank you.
All right. So that is clear. That is clear. Any other question? Anyone with a question so that we can run through and address a few things? No one has a question. So I'm just going to project a question quickly so that we can start with it, and then we can run to other things that we have lined up for the day. I'm just going to project something quickly because I was just looking at it and I was like, okay, this is something that we can also we can discuss quickly. Okay, so can you see my question? My screen, that is.
Yes, we can see.
Okay. Somebody read for us that question quickly. I just want us to break the ice with this question. That is a question on lease. We've done leases, guys.
Question 6. A. Industrial Park Limited advocates have forwarded you a draft lease for review on behalf of your client, of your tenants. I don't know why the Bible pen is saying of your client. The lease is for the
you read what you can see.
Yeah, I have seen the word client. Let me repeat. Industrial Park Limited's advocates have forwarded you a draft lease for review on behalf of your tenants.
Of your clients, the tenants.
The lease is for a commercial property. Discuss at least 3 pertinent clauses that you must ensure are in the lease document prior to the execution by your client.
Quickly, guys. This is something easy. This is something easy. Put up your hand quickly. Guys. Guys, are we in this class? Guys, are we in this class? Guys, are we here? Okay. Guys, can you hear me? Guys, can you hear me?
Yes, we can.
Why can't you guys put up your hand and talk? You guys want to discuss this question? All right, let's get to the topic of the day. Now, today I want us to talk about sectional properties. In the last class, I told you guys that we need to discuss. If we can't discuss, then there's no reason of us having a past paper question. The thing is, we can go through the teaching, and then when I put up a question paper, we discuss. It is a question paper. We discuss it. You guys are close to 170 in this class, but you guys are not putting up your hand. So that past paper question is down. Now I want us to go through sectional properties again. No, we haven't gone through it, so that we can see a few things and understand how sectional properties work. Okay, I want us to do that and see how sectional properties work for purposes of you understanding and preparing for your exam. Okay, now since the incorporation of the new 2020 Act, not much has been done. Not much has been done in as far as setting the question on sectional properties, but they do come in a few. We'll see a few, one or two questions regarding sectional properties, but not much has been said. But of course, as the years go by, expecting one question this year on sectional properties, you need to understand sectional properties. Are you together? You need to understand sectional properties. That is one thing that you must understand. So all of you have heard about sectional properties. You have heard about sectional properties, okay? All of you have heard about sectional properties. So we are starting from a point of information, okay? Now, before we get into the discussion of what sectional properties are, what really these things called sectional properties are, you must understand where we are coming from, okay? Are you together? You must understand where we are coming from as a country. Are you together? Guys, are you?
Yes,
can you hear me?
Yes.
Yes, we can.
Yes, we are together.
All right, perfect. Now, for all of you, or some of you that lived long time ago, you note that even if you go and do a search of the old Nairobi, you'll find that there are a lot of spaces. There used to be a lot of space in Nairobi. In fact, everybody in Kenya could get a space in Nairobi. Everybody in Kenya could get a space in Nairobi. Okay, and that is by, I mean, they could get their own spaces because there was so much space. I think there was a time that the population of the country was around 3 million, and then it came to 5 million, and then it went to 10 million, and then right now we are pumping 50 million. So you understand that we came from a place whereby the population was so small. Okay, now if the population is small, remember that land doesn't multiply. Land is just land. Okay, land is just land. Are you together? Land will not multiply. Okay, so if the population was small, it means that every person could get a space. Every person could get a space. Are you together? And that space, I don't know why these people, guys, if you have a full name, if you're given 2 names at least, join the class with full names. I don't know why you're saving another name for. I don't know who you're saving it for. So join the class with full names so that we save time. All right. Thank you. Sawa. So what I was explaining is that when you look at the population then and the population now, land has become too rigid because the population has grown. Okay, so in Nairobi, let's say in 1960, everybody could get their own compound. If you're building your property in Nairobi, you could get your full compound, okay, your own entire compound. Now, as time went by, the population increased, okay. After the increment in the population, then not everybody could afford their own compound, okay. Not everybody could afford their own compound, okay. So the problem that that came by is that the land that was available within the borders of the country could not sustain everyone. Not all of us can live in Nairobi and have their own compound. Okay. Now, for that reason, we needed to address an issue. Okay. We needed to address address an issue. Okay, what is the issue that we are addressing? We are addressing that specific issue, that how then can we accommodate the people that are not able to get their compound. If you're not able to get your compound, maybe because the land is rare and it is expensive, how then do we help you? Okay, how then do we help you? And then what came about was the Sectional Properties Act of 1987, the 1987 Act. Now this act now came with a resolution. And what was the solution to the problem? That look here, we can divide, okay, we can divide buildings, okay, into now apartments. You can have an apartment, and one apartment, if you have a 100 by 80, you can build your apartment there. You can have 100 floors, and a lot of people can live there. Initially, it was just 80 by 100 for one person. But if you build your house and you divide them into units going up, you can have as many as possible, as many people as possible. Are you together? Now, that was the question of division of building into units. That was what the solution was at that time. And then the other problem was this. The other problem that came was this. Okay, these people that were staying on these apartments also wanted to have a title to the property. Okay, if you're staying on an apartment, you wanted a title to the property. You wanted also to own the apartment or the unit. And that is a solution that was sorted by the 1987 Act. Okay, the solution that was sorted by the 1987 Act. Now, how did the 1987 Act sort that? By bringing what you're calling the sectional titles. Okay, now so far we have addressed two issues. Okay, we have addressed two issues. What is the first issue that we have addressed? The first issue that we have addressed is that we are now able to divide the units, we divide buildings into units. It means one tall building can have different units. Okay, that is the first problem that we have sorted. So that if you can't get your own compound, you can just get an apartment and live on the second floor or the third floor or the fifth floor. And at the end of the day, you can realize that even 100 people are staying on that apartment. Okay, that is the first problem that we have sorted. The second problem that we are sorting by the Sectional Properties Act of 1987 is that now you, as the person staying in house number 1, house number 2, house number 3, you can now own your title. You can have a title to that specific, a specific house. Are you together? You can have the title. Okay, that is another challenge that we have now sorted. Okay, so that is the Sectional Properties Act of 1987. Now, that specific act came to sort those two issues. The first issue is that if you can't afford your own compound, because as people grow, Kenyans are giving birth very religiously. Okay, so as the population is going up, the challenge is you can't have your own piece of land. Look at even your family. In the days of your grandfather, there used to be a lot of land. And then your grandfather came, your father and your uncles came, and now you are there now. So the piece of land did not multiply. It is the population that increased. And therefore, if your grandfather was given 10 acres, now you as the great-grandchild, you might have just an acre or an eighth of it or an half of it. Okay, so as the population grows, we realize that not all of us can have land. Some of us will buy land, some of us will only buy apartments. Okay, now the second problem was, can I own that apartment? I want to own it. I want it to be mine. Can I have it? Okay, that is the problem again that was sorted. And how was that sorted? That was sorted by the introduction of the sectional titles. The sectional titles. So you can buy an apartment and you get a sectional title. Okay. Now the 1987 Act had got some restrictions. Okay. It said that if you have a freehold property if you have a freehold property, within that regime, you could build your apartments and then register them under sectional properties. Okay, you could do that. However, if you have a leasehold property, you could not. Okay, you could not, unless the term remaining on the lease. Remember, guys, leases are coming from the government. So if you have a lease from the government, you cannot build your apartments there and then register them under sectional properties. Why? That is a borrowed land. Okay, that is a borrowed land. It is a borrowed land. Guys, are we together? It is a borrowed land. It is borrowed from who? From the government. Are we together? Now, if it is borrowed from the government, what is the condition? The condition is, okay? As I'm telling you every time, you need to join the class with your full name. Full name. I don't know why you are hiding your name. Your names are not really beautiful. They're not really nice names. So just tell us your name there. Don't hide your names. Yeah? Kama wewe ni Kang'ethe, sema wewe ni Kang'ethe. Kelvin Kang'ethe. Piga tu hapo Kevin Kang'ethe. Okay? Sawa sawa. So that was the 1987 Act. So if you had a freehold property, you could build your apartments, register them under sectional properties, divide them into units, and then sell the individual units to any person that wants to buy the units. Okay, but if you had a leasehold property, you could not register them under sectional properties. Okay, why? Until you have at least 45 years remaining on the lease. Most leases were for 99 years. So for you to, fall under the sectional properties, you must have at least 45 years remaining. By the time you're registering that property under sectional properties, you need to have at least 45 years remaining so that the individual unit holder that you're going to sell the units to are given their own titles for at least 45 years. Okay, so if you had less than 45 years, you could not get under the Sectional Properties Act for those who are having leases. Now, what was the remedy for these people? They fell under subleases. They fell under subleases. And I explained this in the last class, and I said, now under subleases, assuming that, which building do you all know? Which building is all known the entire Nairobi? Let's say the KICC. So you guys know where the, yes, the KICC. So let's assume that the KICC is the building, okay? The KICC is the building that belongs to B.R.N, okay? So the KICC is the building that belongs to B.R.N. Now that building is on a lease. Let's start with a freehold property. It is a freehold property, okay? So B.R.N will construct the building as you can see it, okay? And then sell the individual units. To who? To the people that are buying. So all of us, if you want to buy houses from B.R.N, we just go to KICC, we pay, we are given the title. So we have the sectional titles. B.R.N will give us sectional titles, okay? So if you have the ground floor, house number 1, that is your house. You can do whatever you want with it, okay? But if B.R.N, or if this property was resting on LR number 123/1, okay, it means it is a lease. Then for B.R.N to consider sectional properties, the term remaining on the lease must be 45 years and above, okay, for it to be under sectional properties. So if B.R.N looks at the lease, the term remaining, and he realizes that the term remaining is 40 years, okay, then what is the option available for B.R.N if he's still interested in selling the units? Okay, guys, you've seen this when you walk around Nairobi and also on the main highways. You are on Wayaki Way, you're on Langata Road, you're on Ngong Road, Jogo Road, you're on Thika Road, you normally see those posters like to sell, stroke, rent, or for sale, stroke, let. So it means they're letting at the same time they're selling. Okay? So renting is different. Renting is different. Are you together? Renting is different. But if you are selling, then it means you're transferring an interest there. So that will fall under sectional properties. So let's go back to KICC. The building that belongs to Bishar, it is a lease or it is resting on a lease. That building is the land that building is resting on is a lease for 99 years. Okay. But at the time that Bishar is considering developing it and selling the units to people, the term remaining is 40 years. Now, for this instant, Bishar cannot go under sectional properties. The only available option was the RTA, okay, the subleases. Remember that RTA system or the titles that were issued under the RTA were leases, and therefore also subleases were falling under the RTA. So Bishar could only go under the subleases. Okay, how is that supposed to happen under the subleases? So what is going to happen is you build your apartments on that piece of land, okay, on that piece of land, and then you are going to create, assuming that Bishar wants to have 100 units on that KICC, 100 units. So you're going to create 100 subleases. Okay? You're going to create 100 subleases out of this lease, and then you're going to sell them. Okay? You're going to sell them. Are you together? So you sell the subleases. Subleases are also titles. So because you can't go under sectional properties, you're going to go under the sublease system, whereby you create a sublease out of the mother title and you sell the individual subleases to people. Now, if the sublease expires, then Bishar will have to renew the subleases for these people. Okay? Or if the mother title, which was for 99 years, expires, then Bishar will go back to the government, will renew the lease, the mother title, and then will come back. Okay? Will come back and renew the leases, the subleases for each and every unit holder. So that was the system then. That was the system then. Are you together? That was the system then. Are you together? So please understand that. If you're not understanding it, don't worry. I'm going to repeat it 1,000 times so that you understand and it sticks. So, sectional properties. What should come to your mind when you see something written sectional properties or when you hear sectional properties? This is a system of division of houses or building into units. The first one, you divide them into units. Guys, I'm not talking about rooms in your house. No, not the rooms in your house. That's not a unit. I'm talking about the apartment you are staying. In the apartment you are staying, there could be 20 houses. House A, B, or 1A, 1B, 1B, 1C, all those things. So those are units. Okay? Those are units. So the idea of coming up with a building and dividing it into a lot of, because originally, let's go back to mankind. Originally, one house, one person. Okay? If you go back to the traditional village setting, one house, one person. One house, one person. Okay? But as things proceeded, we now started seeing people building the gorofas, as you call them. And then now you find that the person living in the first floor is different from the person living in the second floor. Okay? So that entire idea of having one building, but having different units and different people living there, that is falling under sectional properties. Those are the sections we are talking about. Those are the sectional properties we are talking about. So those sectional properties will be found within a building. Okay? So it applies to buildings that are divided into units. Number one, buildings divided into units. Are you together? The second idea about sectional properties is that these units are not owned by one person. Okay, or these units, they're not, it is not like one person is building their house and they have first floor, second floor, and third floor. No, they are distinct units. Okay. Number two, that these units are owned individually and differently by different people. Could be different people or the same person. For instance, I'm saying you can have your entire apartment. You bought the entire apartment from house number 1 to house number 50. Those are your houses. That is still sectional properties. So the fact that there are different titles for each and every unit in that building, that is what forms the idea of sectional properties. Okay, so when you think about sectional properties, I want you to think about a building divided into units, and then these units owned differently. Okay, they are owned differently. There are different titles for each and every unit. Okay, now that is the entire idea of sectional properties. Number two, it doesn't apply to bare land. If you have some land somewhere in the village and you want to divide it between, between you and your brother or among your brothers, that is not sectional properties. Okay, that land that does not fall under sectional properties. Sectional properties is the idea of buildings. There must be a building standing. For you to register a sectional property, there must be a building standing and not a hall. Okay, not a vertical hall or an horizontal hall. It must be a building that has different units, divided into different units. And those units must be at least more than one unit. So if you just have one house, that is not a unit within the sectional properties meaning. So it must be at least one unit. And then those units will give us different titles. Are you together? Now, let us do the shift from the old act into the new act. So the old act said, if you have a freehold property, you can safely register under sectional properties, build your apartment, divide them into units, and then sell the individual units as you give the people that buy or the purchasers sectional titles. Okay. However, if you have a lease, the remaining term must be 45 years. The remaining term must be 45 years. If it's not 45 years, we are sorry, you can't have sectional property regime under that or in that property. Okay. Now, in 2020, that was done away with. Sabusaga, I'm coming to you in a minute. That was done away with. We amended or we repealed the 1987 Act, and now we brought the 2020 Act. So we have the Sectional Properties Act, the Sectional Properties Act of 1987 deleted, and the Sectional Properties Act of 2020 coming into force in December of 2020. That's, I think, 11th of December 2020. Okay. Now, this act is coming with new changes, new good news and new changes. Okay. Now, what you need not to forget at this moment is, remember that when you had a lease, you must have attained at least 45 years remaining. Anything that was below that, you could only sell it under subleases. Okay, anything that was below 45 years on a lease could only go under subleases. Are you together? So note that point, put a start to it. We are coming back to it. We are coming back to it. Now, in the 2020 Act, the first thing that was amended was the 45 years requirement. So it was reduced from 45 years until 21 years. Okay, until 21 years. So the act is saying that long time ago, okay, long time ago, you guys used to have 45 years, but now you guys are having 21 years. Okay, we have introduced 21 years. Okay, so the limit on leases has been reduced from 45 years to 21 years. So if you have 21 years now, you can still build your apartment, divide them into units, and then sell them under sectional properties. Okay, sell them under sectional properties regime. 21 years was introduced. And of course, you know, Section 7 of the Land Act says that any long-term lease of more than 21 years is capable of conferring a title. So if you have a lease for more than 21 years, you are capable of conferring a title. So if somebody transfers you a sublease for more than 21 years, you get a title. Okay, so it has been reduced to 21 years. The second thing that the new act has come with is the question of the titles. Now, in the old act, we used to call them sectional titles. Sectional titles. Remember, we used to have different types of titles: the RTA titles, the RLA titles, the GLA titles. We used to have them, the sectional titles. Now, in the new act, under the Land Registration Act of 2012, we have centralized all systems of registration. We have centralized all systems of registration. Okay, and we are now calling them certificate of titles or certificate of leases. So as well, if it is under sectional properties, if the property was a freehold property, the title you're going to get is a certificate of title. If it was a leasehold property, what you're going to get is a certificate of lease. We don't have sectional titles anymore. Are we together?
Yep.
Guys, are we together? All right. Lastly, before I take any question, the next thing that the new act has come with is the question of conversion. Conversion. What is this thing we are calling conversion? Okay. What is this thing we are calling conversion? So remember the point I told you to put a star on? Those people that did not have 45 years and below, their only remedy was subleases. Okay. Their only remedy was subleases. Are you together? Because they did not have at least 45 years remaining. So they went to subleases. Now, with this age, sorry, not age limit, but I mean the number of years being lowered until 21 years, it means there are some people that have more than 21, but had less than 45. So they're falling in between. So if you have more than 21, and by that time you could not fall under sectional properties, and you went to subleases, you need to convert those long-term leases into sectional properties. So they are allowed to convert. We shall talk about conversion later before I confuse you more and more. Sabusaga Davis.
Thank you, Mwalimu. My question is in regards to, I have seen some properties being developed. Let's say it's on 40 by 80, or maybe that's smaller, or a piece of land that is an eighth. And then you find that this person has constructed several units, not the vertical ones that we talk about in sectional properties, but they are separate but within the same piece of land. Are they also covered under the sectional properties?
Yes. You talk about the townhouses. Townhouses, I'm talking about you have your own compound. I have my own compound, but all of us were existing on one title. Is that what they're saying?
Yes.
Yes, so that is still sectional properties because you have one title that has a lot of units. Okay, one title which is LR number 134/1. So assuming that that one title is stretching from gate A of KSL up to gate C. Okay, so each and every person has their own. There's no apartment, there's no ghorofa anywhere. Kila mtu ako na nyumba yake, imepangana hivyo mpaka gate C. Nyuma tena zimepangana hivyo mpaka gate C. So all of you are existing on one piece of land, which is one title. Okay, so that will still form part of sectional properties. So long as you are sharing a title, that is still forming part of sectional properties. Are we together?
Yes, thank you, Mwalimu.
All right. Any other question? We are still just introducing this thing. Any question? Sandra Njau.
Yes, Mwalimu, you
spoke about that sectional properties also apply to different titles for different units. I didn't get that.
What do you mean?
What it means.
I'm
Where
also
you say
confused
that
about
units
units.
units are owned by different people.
Okay.
Yeah, I didn't get that part because you also said that it could be I have built the building and I own all the units. But then what do you mean by when you say that they are owned by different people?
What I mean by different people is where you're staying. I'm assuming I'm making a very great assumption that you're staying somewhere that either on apartment. Let's say you are staying on apartment. So when I mean different people is I mean that the person that is staying in house number 1 is different from the person staying in house number 2. Is different from person staying in house number 3. Even where you're staying right now. Is the neighbor your sister or your mom? No. You could be different people from different places. Okay, what is bringing you together is just that apartment. All of you like the apartment, so each of you are renting an apartment there. So you could all buy an apartment there, so that if you go to house number 1, it is owned by Stephen. House number 2, Abdi. House number 3, it is owned by let's say Susan. Second floor, third floor, Ivo. That is the first instance. The titles, the units are owned by different people. Okay, the units are owned by different people. It means you built your apartment as Njau, and then those units, you sold them to different people. Number 2, there's an instance where if you build your apartment, 50 of them, 50 units, you buy all of them, they belong to you. So all the titles are reading your name. Or you as you as Njau. Are you there? I hope you've understood what I've said. Njau, are you there? I hope you've understood what I've said. So if you as Njau, for instance, you are an investor, okay? You are an investor. You want to invest in real estate, okay? And you've had some dream that in the next 10 years, the price of housing will go up in Nairobi. So what are you doing? You're buying apartments. You're buying all apartments in Nairobi and keeping them for yourself so that in the next 10 years, you can sell them. Okay, so that is what I mean. So you can buy an entire apartment. The same way you can just buy one house, there are people that have money that can buy all of them, the 50 of them. So if you buy all of them, so long as they're different units with the different titles, that is still sectional properties. Are you together, Sandra? Was that Sandra?
Yes, Mwalimu, thank you.
All right, so that is what I meant. Any question as to what amounts to, yes, Rhys, Aaron?
Yes, Mwalimu, thank you. I hope you can hear me.
Very well.
Yeah, I would like to take you back to the point where you were discussing the subleases under the RTA, and you mentioned something, you introduced something regarding mother titles. And you were giving us an analogy of Bishar owning the KICC building, resting under a title, a leasehold title, and he's having less, is it 40, less than 45, or it's about 45 years remaining? So I kind of lost you there. My network was a bit shaky. If you don't mind, just to like
I don't know exactly what your question is. You've not answered. You've not asked the question. I don't know what I said there. I say a lot of things. So what is the exact question so that I know exactly what is confusing?
Could you kindly just recap or repeat on the subleases under RTA and where you introduced the aspect of
I've not discussed subleases. I've not discussed subleases at all.
No, you mentioned the remedy for the people who had the 45 years remaining, had the option of registering under like a sublease. I don't know if
Can you give me a specific question? If you can't, I need to get I don't know exactly what I said that
Yes.
confused you.
Yeah.
Okay. I've said a lot of things, a lot of words back and forth. So I don't know exactly what I said, at what point I said it, that you got lost. So if you'd led me and tell me that this point is confusing me, I can be able to help you. But the question on subleases, we have not discussed them. We will discuss them later. But let me try and figure out what might have confused you, because I'm not very sure. But I said that
Yes.
if you have a sublease, if you have a lease, then because you can't fall under section of properties because of the number of years being less than 45 years, you can't fall under section of properties. The only remedy allowed is you go under subleases. Okay, so how does that work? You are going to create subleases. Okay, for each, and remember, the mother title the building is resting on is a lease, and therefore all the units will have subleases. All the units are going to have subleases. Okay, so you're going to sell them as subleases. Why are you selling them as subleases? Because the mother is a lease. So it's like this land has given birth to 50 units on top of it. So each and every unit will be a sublease. So you sell them as a sublease. Why? Because they are created from the lease, which is the mother title. So we are going to discuss the difference between a lease or between subleases and section of properties. We'll discuss that in a minute, so that you see why for this one it is a sublease and why for this one it is a section of property. We are going to discuss that. But I said, because of that instance, the mother title is a lease. The only title you can create from it is a sublease, because we are not selling the mother title. We are only creating something from the mother title for everyone. So that is a sublease for each and every person. I don't know kama tunaelewana. What I'm saying is this.
Okay.
Let me use another example. You have your building with 50 units. There's only one title. Okay? The title is just one. LR 131/1. That is the title. Okay? The certificate of lease. Who is holding it? Bishar. Now, Bishar cannot divide that title into 50. Okay, you cannot just take the title and tear it into 50 parts and give each person their share. No, that can't happen. So what will happen? You create a sublease out of that lease. You can't divide the paper into 50. So you will create a sublease out of that lease. Right, together, you create a sublease out of the lease. Create a sublease out of the lease. So the lease, which is the main document, will now give birth to other titles, which are now subleases. Okay, that is what we're saying. If it was freehold property, we just take it through section of properties, close the mother title, and then give every person their own. Tunaelewana?
Yes, mwalimu, tunaelewana. Thank you.
All right. Last question is Isabel, and then we can start. Guys, it's okay. It's okay. If you're not understanding something, ask. If you're not understanding something, ask, because if you don't ask, I will assume that you know. Isabel?
Yes, mine is a follow-up to the question that you've just answered. You partially answered what I had intended to ask. So when let's say the properties are freehold and you've constructed apartments on it, so the final title document that the buyer is going to have, let's say in both the freehold and the leasehold system, what will they be called?
All right.
Yeah, that.
So for us, a freehold, we said for freehold, where you go to section of properties. So it's like a gate. So the registrar will be telling you, what title do you have? I have a freehold. Gate one is section of properties. Section of properties, this side. What title do you have? I have a lease. How many years remaining? 22 years. Side nyingine, subleases. So the final title you are going to have as a unit holder in a freehold property is a sectional title, which is going to come as a result of us closing the mother title, and then we open new titles for each and every unit holder. when it comes to sectional properties. Okay, but for the subleases or for the sublease system, or for where the lease is less than 45 years, we're not closing it. We're not closing it. We're just creating subleases out of it. So if every person is going to get themselves a sublease, and I've said this over and over again, a sublease is a title. The same way you have a title deed under the bed, that could be a sublease as well. A sublease is also a title that you can sell, you can take to the bank, you can charge it. Whatever you can do with your title, you can do with a sublease. A sublease is a complete title. Tunaelewana?
Yes, yes. Thank you so much.
So sectional properties, you get a certificate of lease or a certificate of title, depending on the mother title, okay? Subleases, where the lease did not meet the requirement of 45 years, you get a sublease. Tumeelewana hapo? I hope that is clear. I will come back to it. Don't worry if you're not getting anything. It's okay. So that is what the history of sectional properties is. So understand it from the fact of the division of, buildings into units. Now, what are the elements? What are the elements of sectional ownership? Okay, so we are starting on the question of sectional ownership. What are the elements of sectional ownership? The elements of sectional ownership. What are they? The first one, the division of buildings into units. Okay, there is no sectional ownership if you're not dividing buildings into units. Okay, that is the first one, as defined under Section 2 of the SPA. That is the Sectional Properties Act. So division of buildings into units. Okay, we build them. We have a building, we divide them into units. Number two is that these units have their own titles. These units have their own titles and they are owned distinctively. Okay, so the ownership of these individual units independently, so that the person staying in house number one has got their own title. If you go knock their door and you ask them, why are you living here? They will go under their bed and they'll come back with their title. Okay? If you go to house number B, ask them, who are you? Why are you staying in this house number B? They'll go under their bed, they will draw a title and they'll show you, this is my title. So the fact that that unit has a title, that is an element of a sectional ownership. And then the third element of sectional ownership or sectional properties really is the question of the common ownership of the common areas. Okay, so if it is a building, every person will own the units, the individual units, okay, but the remaining common areas will be owned in common. Will be owned in common. Owned in common simply means that it will be owned by everyone that has a property there, everyone that has a property there. And remember, guys, everybody that has a property there will own the common areas. What are the common areas? The parking. The parking space is a common area. Okay? If there's a recreational facility, the gym, the swimming pool, the gate, the wall around the gate, the staircases, okay, the lift, okay, the rooftop, for instance, okay, those are common areas. So all those places will be owned by everyone that is having an apartment in that specific building, okay? And the ownership will depend on how many units they're having. For instance, if there are 50 units, okay, if there are 50 units, what is your share of the common area? Because remember, under common ownership, we are saying everybody has a distinct ownership. There's joint ownership and there's common ownership or ownership in common. For joint ownership, nobody has a share. Everybody owns everything. Okay? So you cannot tell who owns what. When it comes to this section of properties, we're saying the common areas are owned in common by all the unit holders. So what is that? Because one of the elements or the characteristics of ownership in common is that every person has a distinct share. We can say that this person has this amount of share in this property. So if there are 50 units, then your ownership of the common area is 1 out of 50. Okay, so that if we are supposed to sell the common area, maybe for 10 million, we have sold the common area for 10 million, we have sold the swimming pool, we have sold the parking for 10 million, then the money that you're going to get as the person staying in house number 1 is just 1 out of 50 times the 10 million. House number 2, 1, so everybody will have 1 out of 50. That is if you're having 1 unit. But if you have 10 units in that place, so 10 out of 50 times 10 million. So that is your share of the common ownership or the common property. If it is just 10 units, the building has got only 10 houses. So it means you are 10 of you. So 1 out of 10 times the value of the common area. Okay. If you have 2, you could be rich. Okay. You will buy 2 apartments there, 2 houses there. So you have 2 out of 10. If someone is richer than you, they will have 5 out of 10. So the amount of benefit, not really benefit, but your share in the common property will depend on how many units you are having. Are we together? So that is the elements of common, of sectional properties. The first one, division of buildings in the units. Number 2, ownership of the individual units. Okay, and individual units being given the titles, and then we have the common. We have the ownership in common of the common areas. Are we together? So that is what you're calling the elements. So if you talk about, if you see a question talk about a building being divided into units, or someone trying to divide or partition or divide the building into units, that is a sectional property. Why is it not a sublease? Why is it not a sublease? Because after 2020, no one is allowed to have a sublease. Nobody is allowed to have a sublease. Why? The registry, the land registry, is no longer registering subleases for buildings. So subleases for buildings are no longer registered. So you can't have a sublease for a building. All the buildings you're currently seeing in Nairobi, all the apartments that are currently being sold in Kilimani, wherever, Kileleshwa, whatever place, Westlands, all of them are being sold under sectional properties. However, 5 years ago, they were either being sold under sublease or sectional properties, depending on which one you want. But right now, the government has said no. When it comes to registration of a unit of a building, we don't want confusion. We want one system, which is sectional property. So from now onwards, nobody can register a sublease over an apartment. It was done deal when the new act came in place. And that is why the new act told them that if you are out there and you have a sublease over your building, convert it to become a sectional property. Tushaelewana? Meshika? Usawa? All right. So the scope, I can see 2 questions. I only take 2 questions only. Rachel and Penina. Rachel, you go first quickly. Time is not on our side.
You said you can't register sublease. So what if you have a lease on that land and it's less than 45 years? How do you register it?
Wewe. Unafaa kiboko. What have I just said? Guys, I've just explained it. Rachel, repeat your question so that everybody can hear what you just said.
If you have or the land is being leased and it's a lease that's now less than 45 years, and you said you can't register it under sublease, what do you do?
Somebody answer that question. Huh? Guys. Yes, Juma.
Okay, I think from what Mwalimu said, with the new current regime, they reduced the period for when you can get, is it a certificate of title, of a certificate of lease to 21 years. So if it is more than 20, if it is 21 years and above, but still less than 45, you can still register it in the new regime as a sectional property.
Thank you. Rachel, are you answered? Are you in this class?
Yes, I've
Are
been
you,
answered.
are you stressed? Is somebody stressing you? Huh?
A little, but I'm fine.
Why is somebody right now? There's exam, my friend. Let nobody stress you. Ambia huyu mtu asikupe stress ai. Haya. Penina.
Oh, yes, Mwalimu. So does it, since you have said that in the current regime, the Sectional Properties Act of 2020, does it mean that if you had registered before in the 1987 regime, if you had registered that lease under sublease, you are supposed to convert it into sectional properties? If
That
now
is what I
the
said.
remaining, okay.
So you have to convert it. If it is a long-term lease that is able to confer title, okay? So if you registered it under subleases kitambo, and bado the term remaining on that lease is 21 years, you convert it to become a sectional property. You convert it, and that's why I talked about conversion. Are you together?
Yes, thank you.
Okay. And that therefore also means that if you have a property that is less than 21 years now, you can't have a sectional property. You can only you cannot sell those units. You can't sell the units. You can only rent them out. Okay, until you extend the lease or renew the lease. So once the lease has been renewed and it is now more than 21 years, you cannot build your apartments and have them under sectional properties. All right, Juma, I don't know whether that's the question. That is an old hand.
Sorry, it's an old hand.
All right. So what is the scope of the Sectional Properties Act? I've said, guys, it is for freehold properties and as well as for leasehold properties. For freeholds, absolutely. For leases, at least 21 years must remain. At least 21 years must remain. Okay. All right. Now let us talk about now the process. How do you handle now sectional properties? How do you handle it? Okay, fine. You have the land. You want to, how do you structure the transaction? How do you structure the construction? I mean, really the entire arrangement to end up with a section of properties. Okay, the procedure of coming up with a section of properties. That's what I'm saying. So it will start from the preparation of the sectional plan. The preparation of a sectional plan. So the first thing you're going to do is to hire a surveyor. If you're writing down, write down. You're going to hire a surveyor. Okay? Hire a surveyor, a licensed or a registered surveyor. Okay? Are you together? So that is the first thing. Surveyor. You must have a surveyor. Okay? So once you have the surveyor, what is the surveyor going to do? The surveyor is going to prepare the sectional plan. Sectional plan. Sectional plan, guys. Sectional plan. Now, what is a sectional plan? You guys have seen building plans. Okay? Some of them are sold everywhere in town. If you're just walking in town and those people know, they know those who want to build houses. They just look at your face and see this one. Huyu amechoka kuwa tenant, waja tumuuzie plan. Wanakuuzia tu, wanakuapproach. You know those hawkers, they just sell you what they think you need. Okay? They sell you what they think you need. So they will sell you the plan. So also if they've never sold you any plan, you might have seen a plan or you must have seen a plan. A plan is just a plan. How the house will look like. Okay, this one will be the first floor. This one will be the bedroom. So that is what I'm talking about. So it is not something so different that what is this sectional plan? No, it's just the building plan because the sectional plan is prepared from the building plan. So of course you have to get the approvals from the county government. Anytime you want to build, you must get the approval from the county government. Approving your building plans. So you don't just build anything without the approval of the county government. Okay, that is the building plan. So from the building plan, you develop the sectional plan. And I've said sectional plan is just a pictorial or really a diagram showing the structure of the building. So if it is a 50-story building, you'll be having first floor. How is the first floor going to look like? Okay, this is the first floor. This is where the stairs are going to be. This is where the lift is going to be. This is the second floor. This is room number 1, room number 2, room number 3. Okay, this is the rooftop. These are going to be the wall. This is the parking. So that one is what you're calling the sectional plan. Okay, showing how the sections are going to be looking like. So once, and that is only prepared by the surveyor. Only surveyors prepare the plans. Okay, only surveyors prepare the plans. So you prepare the plan. Once you prepare the plan, you proceed and apply for the registration of the plan. Okay, registration of the plan. All together. So get a surveyor, have them prepare the plan, and then the plan is registered. And that is how you get your sectional properties. But there are certain things you need to do before you end up with the registration. The first one I've said, you have to obtain the building approvals from the county government. The county government must give you the approval to build. You can't build without the approval. Okay, so if your client is telling you that they've acquired some piece of land, or they're trying to acquire some piece of land to construct, then one of the approvals they will need are the county government approvals. Okay, the respective county government will have to approve that specific plan. Okay, also, once you prepare the sectional plan, it must be georeferenced. Okay, the georeferencing. Okay, georeferencing is simply putting the property on the map. So right now, if you go to your Google map and you just type the name of your apartment, you'll find it there. It didn't find itself there by accident. It was placed there. It was georeferenced, it was placed there. So surveys and the maps, they work together. Okay, so it is georeferenced. Once it is georeferenced, now you apply for the registration of the sectional plan. Okay, the initial stage of registering a sectional property is by preparing the sectional plan, which is prepared by surveyors. Once they prepare it, they georeference it. Once it is georeferenced, you apply for what you're calling the registration. You apply for registration, which is done at the land registry. Everything land is land registry, guys. Okay, everything land is land registry. So you apply for the registration of the sectional plan. So what is going to accompany that application? What is going to accompany that application? What is it that is supposed to accompany the application? What is it that is going to accompany the application? So the first one, of course, is the sectional plan. You have to attach the georeference sectional plan. Now, guys, when we talk about georeferencing, I want to understand something about georeferencing. You cannot georeference a building that is not there. So the sectional plan can only be prepared once the building is standing. The sectional plan comes after the building is standing. We have the building plan, which is just the building plan. Okay, the building plan comes before the building. So you build, you buy the plan, and then you build. Once you build, you prepare the sectional plan now, and then once the sectional plan is prepared, the building is georeferenced. Once it is georeferenced together with the plan, then you apply for registration. Altogether. So as you're applying for registration, what are you attaching? The sectional plan, georeferenced, number one. Number two, you are attaching the title, which is the original title. If it is a lease, the original certificate of lease. Okay, you attach that. The other thing you're going to attach are the approvals. Okay, approvals from the county, the building approvals from the county. You have to attach that also as well. And then another thing you're going to attach is now the application for the registration of the corporation. We are going to talk about the corporation later. We're going to talk about the corporation later, but when you are applying for the registration of the sectional plan, you also attach an application for the registration of the corporation. The corporation is just, I mean, all the members of the that, all the unit holders will form the corporation. So that is the sectional plan. So you prepare the sectional plan by surveyor. It is your reference, and then you apply for registration. Now, what are the contents or the requirements of a sectional plan? Look at your screen. What are the requirements of a sectional plan? For you to prepare or to have a sectional plan, what then would be the requirement of that? What then would be the requirement of that? The first one, it must be described in the heading as a sectional plan. You have to write is that this is a sectional plan or sectional plan dash. Okay. Number two, it must be your reference. Like I've said, your reference. Okay. Your reference. The other one, number three, is that it must contain, of course, the description of the property. That is the title. The title must be described. The title must be described. So that is also very important. Very, very important. The title must be described. It must have the drawings. Like I've said, show us where the units are going to be. Okay. As you can see, the drawing illustrating the units and distinguishing the units by numbers or by symbols. For instance, floor 1, floor 2, floor 3, floor 4, floor 5. Okay. It must show the approximate floor area of each unit. Okay. Just like a building plan, the surveyor will give you the plan, and you'll see that this house is going to be 50 by or 500 square meters. Okay. So that one is clear. The approximate floor area. It must also have the numbers. Okay, it must have on it, endorsed on it, a schedule specifying in whole numbers the unit factor for each unit in the parcel. It must be signed by the proprietor of the property. It must be signed and sealed by the officer in charge of survey. Okay, it must also must also contain the address of the corporation, or the address of the developer at that instance. What is the address of the developer? Okay, what is should we want to serve you with a document, where should we get you? Okay, and then it must also indicate the user of the unit. The user of the unit. The user simply means, what is the use of the unit? Is it a residential? Is it commercial? Is it industrial? Is it whichever agricultural? Of course, it can be agricultural, because we are not, you cannot be built, I mean, tilling or farming in a house. Okay, so those are the contents or the requirements of a clear or a proper sectional plan. It must have those things that you can see on your screen. Okay, so the first thing, hire the surveyor. Let's go at it again. First thing, hire the surveyor. The next thing, the surveyor will prepare the sectional plan. The third thing is that the sectional plan must be georeferenced. Once it is georeferenced, you are going to apply for the registration of the sectional plan. Guys, sectional properties come into being by the registration of the sectional plan. Everything else, so long as you've understood the sectional plan, you've understood the whole sectional properties, because it starts with the sectional plan and it ends with the sectional plan. Okay? Once the sectional plan is registered, you have a sectional properties. Tayari. Uko nayo tayari. Okay? So, ni nini nimesema? Surveyor, number 1. Number 2, georeferencing, sorry, the sectional plan. Number 3, the georeferencing of the sectional plan. And then apply for registration. So when you're applying for the registration, what is it that you need to attach? What is it that you need to attach? Number 1, you attach their copy of the sectional plan itself, the consents and approvals from the county government giving you, the mandate to build, the building approvals. You attach the original title, or the certificate of lease, okay, or the certificate of lease, and then you are going to attach an application for the registration of a corporation. An application for registration of a corporation. Okay, you attach that as well. You attach that as well. Tuko sawa? Tunaelewana? Chonjo. Now, once you apply, of course, you have to pay the requisite fee. You have to pay the fee. You have to pay the fee. Now, once you apply, what happens? What happens? Then the registrar shall proceed and register the sectional plan. The registrar, of course, if the registrar is convinced that what you have there is a valid sectional plan, everything is proper. First, you have a building is standing. Why is it that the building should be standing? It is a way to reduce conning. People have been conned by the off-plan purchase. People have been sold titles that are not existing, the off-plan. You know the off-plan ones. Wanakuuzia tu picha. They round up some few people. Okay? Some few people, they round up some few people. And then they will tell them that, okay, give them some few money. I mean, some few coins there. And then they'll come on your television and they'll be saying, oh, I'm happy today. I was in a bad place until I met these people. They gave me a house. Today I'm entering my new house. And then you'll be there wowing and saying, wow, that could be me. Wow. And then they meet you next. When they meet you, you give them your money and you'll never end up on TV. You will not encourage anyone else on TV because your money shall be squandered and they will disappear. That is how they do it. This Ponzi scheme, that's how they do it. They just take a few people, you know, they pay those few people. They give them some very fictitious houses and then they do an advert and they say, oh, these people are legit. These people have helped me. I don't know what I could have done without these people. And you there watching your TV lazily saying, okay, this is what I need. Wacha nijaribu mimi pia. Hey, my friend, guys, when it comes to buying land, one of the most expensive things right now in Kenya is land. Getting land is not. People are no longer inheriting land. I think that one died long time ago. People are no longer inheriting land. We no longer have community land that is being given for free. So if you want to buy land and you're serious with buying land, please don't be lazy. Don't be lazy. Even buying a house, that money is not easily come by. So don't just do your diligence and you buy a house, not today, not tomorrow, just be patient. But if you move fast, that is how fast the money will move from your pocket. And that is how fast you will go back to the village. Yeah. So one of the ways the Ministry of Lands or really the registrar has made sure that people are less conned is by ensuring that before you register sectional property, the building must be standing. Ni kitu tunaona. Si tunauzia watu karatasi. So, but of course, still we have off-plan purchases. We have off-plan, a lot of them. Okay? If you just walk, take a walk in Kilimani. You see a lot of places they're constructing right now. All those houses have been sold. They've been sold already. They're just constructing so that they can give the people that bought them off plan. So off plan is yours because money is yours. Pesa ni yako, wewe utafanya nao kitu unataka kufanya. But remember, ukikuwa conned ni shauri yako. So for sectional properties, the building must be standing. For it to be georeferenced again, the building must be standing for it to be georeferenced. All right, so that is that. So registration. So we've prepared the sectional plan. Now we are at registration. So the moment you register the sectional plan, three things will be happening automatically. So the first one is the closure of the mother register. Okay. Now, guys, titles will come from registers. I told you guys that what is in the registry is not some magic. What is in that building you're calling the land registry is just documents called registers. Okay? Now, each and every piece of land has got their own register. If you have a title deed right now, that title deed has got its own register in the registry. So it is the register that will give you the title. All titles will come from a register. So if you go and open that register, you'll get a copy of your original. The original is with you, but your copy is in the register. Okay? The copy is in the register. You are the one who keeps the original. So the registers will have the titles. Okay? So what happens first is the closure of the mother register. So assuming that our land was Nairobi Block 1. So we are going to close the register for Nairobi Block 1. Okay? So once we close the register, automatically we cancel the title deed as well. So the mother title is closed. It is cancelled. It is closed. Okay? Now, once we do that, what are we going to do next? What is the second consequence of registration? We are going to open new registers for each and every new unit. Okay? New registers for each and every new unit. So if you're going to have 50 units, if you have 50 units, you are constructing 50 new apartments on the property, then, okay, we are going to close the mother register. We are going to close the mother register, and then we are going to open 50 new registers. And from the 50 new registers, we are going to create the 50 new titles for the sectional property. So like I said, guys, that when it comes to sectional properties, rather, every person will have their own title. So how do we ensure that every person has their own title? We do that by first closing the mother title. That is the title for the land upon which the building is resting. We close it, and then we open new registers and new titles for the units. So if the units are 50, we open new 50 titles for each and every unit. Are we together? Now, these units, in the first instance, they are registered in the name of the developer. Okay, in the name of the developer. They are registered in the name of the developer. And then when you buy, the developer transfers to you. When you buy an apartment, mwenye nyumba anakutransferia. Okay, the developer anakutransferia the title. When you buy the apartment. That is exactly what happens. Guys, are we together? Tunaelewana?
Yes, Mwalimu.
All right, so that is the second thing that happens. What is the third thing that happens? The third thing that happens is the registration of the corporation. Okay, so the corporation is registered. The corporation is registered. So three things happen. The moment the sectional plan is registered. What is wrong with this thing? The moment the sectional plan is registered, the moment you register the sectional plan, then three things will happen automatically. The first thing is the closure of the mother title, of the mother register. Okay? That is the first thing that happens. We close it. The next thing, we open new registers and new titles for the units. So then the number will depend on how many units do you have. If you have 10 units, we have the 10 new titles. Are you together? All right. That is the second thing that happened. The third thing that happened is the registration of the corporation. The corporation is registered, and the corporation will include every person that has ever bought a unit there. Every person that has ever bought a unit there. So if it is, let's assume it is Bishar. Let us take it practically. Let us take it practically and assume that Bishar all right, so Let's get at it. So what are we saying? What are we saying? So Bishar is the proprietor. So let's assume Bishar is a proprietor of Nairobi Block 1. Okay? Nairobi Block 1 is land that belongs to Bishar. Bishar has decided that he's going to construct his apartments and is going to sell them as sectional properties. So what is going to happen? The first thing that Bishar is going to do is to hire a surveyor. Okay. The second thing that is going to happen is the preparation of a sectional plan. The sectional plan is prepared. The next thing is the georeferencing. The fourth thing that is going to happen is you apply for registration. Bishar is going to apply for registration. Registration of what? The sectional plan. What do you attach? Bishar, unmute. Bishar, are you there?
Yes, Malim, I'm there.
What do you attach as you apply for registration?
When you apply in the registration, you attach with all the supporting documents, the title, the approvals, then the registration of the corporation.
All right. So that is what you attach. The sectional plan itself, the original title, the building approval from the county government, and then the application for registration of the corporation. Okay. Now, assuming that the registrar has registered the sectional plan for Bishar. Bishar has decided to have 10 units. The apartment had 10 units. So what is the next thing that is going to happen? The first thing that is going to happen is that we are going to close the register for Nairobi Block 1. We close the register for Nairobi Block 1. The closure of the mother title, we close it. This one is a freehold. Nairobi Block 1 is a freehold. Okay? It's a freehold. So we close that register. We close the register. Are you together? Guys, tuko sawa?
Yes, Mwalimu.
Okay.
Yes.
So we close Nairobi Block 1. So once we close Nairobi Block 1, then we are going to open new registers, 10 of them. 10 of them. We open new registers. We close and then we open new registers for the same for the section of properties, and then for the units rather. And then the third thing that happens is we register the corporation. We register the corporation. Okay? And then from there, Bishar can now go and sell his units. Bishar can go and sell his units peacefully. So anauzia huyu akitaka anampea, mwingine akikuja anataka anapewa. Hivyo hivyo. So you sell your units. Guys, are we together?
Yes, we are.
All right, questions up to there? Faiza or Cash?
Can you hear me? And I have a question regarding the closure of the mother register. And so before you said, sectional properties can be created from either freehold property or a lease if you have 21 years and above. So my question was, and what interest is conferred when to those who have like now sectional titles from that? Is it like a freehold or a leasehold when the mother register is closed?
That is very simple. That's a simple question. If a donkey gives birth, do you get a zebra or a cow? Is your question answered?
Yes, it's answered. So is the answer, and if you had freehold before, your sectional title will be freehold. If it was lease, it's going to be lease. Or
we no longer call them sectional titles. We don't call them sectional titles. They're certificate of lease, certificate of titles.
oh, okay, thank you.
Are you together?
Yes.
All right. So just to stress on that point, if the mother title was a lease, everybody's going to get a lease. We create new leases. If the mother title was a freehold, everybody's going to get freeholds. We create new freeholds. Are you together? So the mother will give birth to the children. So the children must look like the mother, okay? Which is a freehold or a leasehold. Usawa? All right. Bishar, what is your question?
Mine is Malimu. We know that nowadays, off plan, we get it everything. We get it the plan, the measurement for the unit, the common areas, and exactly when they do, and that is actually is done by a registered surveyor. So when the building is up, it's built and it's now complete. And my understanding, why do we still need the surveyor? Because we already know that other than not, doing the georeferencing maybe for the purpose of mapping, but we have the units that already we know it. Even the off plan, we get it like the floor, it's 5 units, 3 units are 4 bedroom, one is 2 bedroom. That's how the things is, and people buy it. So can you do it before even the building is complete, that you register for the sectional plan?
No, you don't. You can't register the sectional plan before the unit is complete. Even when you buy it off plan, you'll have to wait until umejenga, umemaliza. So long as building imesimama ndio you apply, because it is a measure. You can't have the sectional units if the units are not there. You can't georeference if the units are not there. Okay. So the plan is prepared by the surveyor. The plan is prepared by the surveyor. That is the work of a surveyor anyway. So the surveyor is the one that will prepare the plan. You can draw the plan yourself, but the surveyor is the one that is going to prepare that plan for it to be accepted at the land registry. So the surveyor will prepare it. That is the first thing. Georeferencing is also done by the surveyor. That is also their part of their work. Georeferencing is also part of their work. So they do it. But it must be at a time when the building is existing. If it is not existing, you'll not get the section of the application accepted. It will be rejected. I don't know kama tunaelewana.
Normally, what about the plan and the approvals whereby the surveyor did before even the construction of the house? The architect plan.
What is wrong with that?
Can you use it? Why are you going right now after the building is up and everything is already clear? Can you use that?
You can't use that. They want their section of plan. What we want is a plan, the section of plan. So you have to prepare the section of plan. That's what the law requires. Prepare the section of plan. So it doesn't matter what the surveyor done before. Right now, when you're registering, tafadhali, utupe section of plan. You get what I'm saying?
Yes.
Yeah, it might not look like it makes sense, but that is what the law requires. So if the law requires something,
you need to be amended, Malim, because they're doing double work.
Yes, you'll realize that you're going to do a lot of double work because the surveyor has already come, has done their work, has done these things, they have prepared the plans and everything else. But now when you're registering again, when the building is now standing, then the law now says you have to start again, So that is, sadly, that is what it is, but that is what the law requires. Ngeta Joy. Joy?
Can I be heard?
Yes.
My question emanates from when you said that when you
What are you saying? Can't hear you very well.
Saying that the question emanates from where you stated that if you have a lease, then units will become leases as well. So, where do the sub leases come in then? I thought a sublease is also a title in itself.
Wewe pia inakaa unapewa stress na mtu. Kuna mtu nakurarua na stress hapo karibu na wewe, si ndio? Unapewa stress siku hizi. I've just explained that and I said nowadays we don't have subleases. Subleases iliisha. We don't have them anymore. Joy, we said we don't have them anymore. Aziko, we don't have subleases because subleases used to exist before the Sectional Properties Act of 2020. For now, hakuna mtu yeyote anaweza register subleases. Tuko sawa? For buildings. We don't have, no, let me make that clear. We have subleases for other things over the land. You can sublease your land. That is okay. When it comes to buildings, you can't sell a building as a sublease. Imeelewana, Joy?
Good.
Joy, I can't hear you. Are we together?
Yes, we're together.
Okay. Perfect. Let's go to Wasike.
Yes, Mwalimu. I'm looking at a situation where the mother title has been cancelled and the building, the construction, the apartments are up, let's say up to 20 floors. And then something happens, like the buildings are destroyed, let's say like an earthquake. And all the building, the whole building comes down. Now, who will be the owner of the main plot on which the building was standing? If this
Depends. That is depends. It will be owned by the owner of the titles. Who is the owner of the titles?
Now you said that each apartment unit will be having an independent what? A title, a certificate of title. Now I'm looking at a situation where all the units have come down, tumbling. What is remaining is only the land on which these units were standing. What is supposed to happen to these people in regard?
Yes, that's what I'm saying. I say that, and I say that Wasike. I said that initially, before we buy, all the titles will be registered in the name of Bishar. Okay? In the name of Bishar. So, nikinunua, Bishar ananitransferia. Kama zilikuwa 10 na nimenunua moja, it means 4 ama 9. 9 ziko kwa Bishar. Moja iko kwangu. So mimi na Bishar, we are the owners of the sectional properties, okay? And 2 weeks later, Wasike amekuja. So tuko watatu, Bishar, Wasike na mimi. 3 weeks later, Isabel amefika. So we are 4. Okay? So it depends. At the time the building is going down, how many people have bought the unit? If none of them has been sold, then the entire unit is still owned by the developer. So that land still belongs to the developer. It's like ulikuwa unauza mayai, kabla upike mayai zimeharibika zote. So umebaki na mafura yako. The same thing. Tuko sawa?
Okay, get you.
All right, lastly is Kezia and then Isabel, and then I can move to something else.
My question, I think you have actually answered, because I was confusing
Okay.
when you had said a developer and a corporation. I was wondering if there are two different people after we said the units now will be under a developer, and then you had said the register is now also under a corporation. So I think I have now gotten it. All if Bishar is the one, the like he was the one who owned the whole property, and now he has units, then it is under his name. Is he the same as the developer? Is it just the alternation of the term developer and corporation? Are they the same thing?
No. Let me explain. Okay. So before the units are sold, there's no corporation. Okay, who is a corporation? The members of the corporation are the people that have bought the units. So if me and Bishar, remember that 10 units, Bishar ameniuzia moja, I'm the first buyer. So who are the members of the corporation? Bishar and I. Okay. If Wasike comes, we are 3 members. If you come later, we are 4 members. Okay. So by the time if the building is going down, when we have the 4 of us as the members of the corporation, then we are the people that own that building. Okay. So if we sell the land, we are going to divide the land according to how many units were you having. At this stage, I have 1, Wasike has 1, and Isabel has 1. So if we sell the land for 1 million after the building imeharibika, so what I'm getting is 1/10 times 1 million. Okay. Wasike 1/10 times 1 million. Wewe Isabel, you get 1/10 times 1 million. And then Bishar, who is the developer still, will get 7/10 times 1 million, because he's having a lot of units still under his name. Okay. So when this happens before he has sold any units, then he will be having the entire units to himself. So he's still the corporation and he's still the developer because nobody has bought the units. So the corporation will include people that have bought the units. So if it happens at the time that nobody has bought the units, the corporation is still the owner. The owner is still the only member of the corporation. I don't know whether tunaelewana, Isabel?
Sasa nimeelewa, yes.
All right. Lastly, that is Kezia. Isabel, lastly.
My question is regarding the mother title in instances where the mother title was a lease. So if this lease was a lease that was given by the government, let's say for 99 years, and now this mother title has been closed, and then these subsequent units have their own certificate of leases.
Okay.
I'm assuming this lease yenye serikali ilipeana it's still running. So when the 99 years lapse, who is going to renew them? Now that
Wewe na mimi. Wewe na mimi na Bishar na Kezia na Wasike. So every person that buys the unit, if you buy the unit and it was a lease, wewe utakuwa lesi wa serikali. So yako expire ni wewe tu solo utaenda kwa serikali urenew. Mimi pia kesho solo niende peke yangu ni renew. Wengine tena solo waende peke yao wa renew. So every person, every unit holder will be having a lease, and that lease will be treated as a lease from the government. So if it expires, you go straight yourself to the government and renew your own lease. That is the difference, the first difference between a lease, a sublease and a section of properties. For section of properties, you renew the leases yourself. For a sublease system, the mother title was not closed, and therefore, in this instance, Bishar will go and renew from the government because he's the one having the mother title, and then he will come back and renew for all of us who are still buying his apartment. But for section of properties, you are not going to the mother title because it was closed. So if this list expires, kila mutu. So if you bought the apartment when the lease was still 30 years or 50 years, you will count. By the 50th or the 45th year, you will get a notice from the NLC telling you, Isabel, your lease of this apartment is going to expire. Apply for renewal. Kama tuwe Safaricom watakutumia message ukwambie your data bundles zinaisha, nunua ingine. The same way when it comes to leases, you'll go to the government yourself because you're the owner of the property. Tuko sawa?
Yes, thank you so much.
All right, so that is that. So the next thing that you need to understand also is the question of the sale. The question of the sale. So we've understood the elements, we've understood the preparation of the sectional plan, we've understood the registration process, and we have understood the effects of registration. Once it is registered, 3 things happen automatically. So the moment imekuwa registered sahi, pap, those 3 things will happen also pap, which is the closure of the mother title, the opening of the new register, and the registration of the corporation. And who are the members of the corporation? Any person that buys a unit will become a member of the corporation. Now the sale. In terms of sale, what you need to understand is what are the documents you must give the person that buys a sectional unit. What are the documents that you must give them? The first one is the title. What is the title here? A certificate of title, if it is a real property, or a certificate of lease, if it is a lease. So the title, number 1, you get the title. So it is a requirement under the law, section 43, that any person that is selling, and you get this question in an exam, I'll find you a question. There's a question like this somewhere between 2022 and 2021. I'm forgetting which specific question, but I'll get it. Don't worry. You'll find a question telling you that your client, okay, your client is selling a property, okay, is selling a property under the section of properties, or he has built units. Now he's selling these units to individual unit holders. Now, advise him on which documents he will be providing the purchasers with. So when you buy a unit, it's a requirement of the law under section 43 to get the following documents. The first one is a title showing that you are owning that apartment. Number 2, you get a sale agreement. Okay, remember this is an agreement. You are buying an apartment, so there's a sale agreement. The same way you are buying land, there's a sale agreement, and then there's a title. So you get a title, a sale agreement. The next thing that you must get is what you're calling the common management agreement. Okay, the management agreement. So remember, it is a common area. Okay, you are owning this place commonly. Let me say that. There's a word like that. Okay, because every person, your neighbors, and all of you are just literally in the same place. For you to exist, you must agree on certain things. For instance, you'll be agreeing on the no doing this. We shall do this. Okay, that is a management agreement. You will have the management agreement. The next thing that you're going to have is a recreational agreement. You must also be given a recreational agreement. Things to do with using the swimming pool, using the parking, using the common rooms, using the gym. Agreement for that should be there, must be there. A recreational agreement. The next thing is the bylaws, the do's and the don'ts, the bylaws. For instance, no parking or no hooting. When you're parking, no hooting. Bylaws, you have to get the bylaws, okay? The next thing that you have to get is a copy of the charge, okay? Before we get to the charges, let me mention the other. Before we get to charges, you get a sectional plan. You must also be given your copy of the sectional plan, okay? Unapewa copy yako ya sectional plan. And then, if the building was built on a security or was used as a security for a loan, if the developer took a loan to build the property, they must give you a copy of the charge. You must get a copy of the charge if that specific apartment was built as from a loan. You have to get a copy of the charge. Is that proper? Is that clear? That is clear. Now, these are the documents you're going to get when you are buying. So you can advise your client, if you are representing the developer, to give these documents, or you can advise your client, if you are representing the purchaser, to have this document. Some of them you'll be drafting yourself. For instance, the sale agreement you will draft. You can be told, advise the documents that you'll prepare in this transaction: sale agreement, management agreement, recreational agreement, the bylaws, Okay, those ones you'll prepare yourself. Okay, so if you're told to mention the documents you'll be preparing, you prepare those ones. Mention the documents you'll provide. You provide the title, sale agreement, management agreement, recreational agreement, copies of the bylaws, the sectional plan, and a copy of the charge if it is there. Okay, a copy of the charge if it is there, if the property is charged. Are we together? Now let's talk about the charges. Now, what if the apartment was charged? Or what if the property was charged? The mother title was charged. For there to be that apartment you're living in, the mother title was charged to a bank. Okay, it was charged to a bank. Now, if the mother title was charged to a bank, then the following things will happen. At the point of registration of the sectional plan, we will cancel the mother title. Like I've said, we cancel the mother title. But as we open new registers and new titles, everything else that was in the mother title will be copied to the new titles. Okay? So what am I saying? If at the back of the title, it was written a charge to KCB, okay? Then it means at the back of every new title for each unit, they are going to write a charge to KCB. So everything that was in the title that was closed will be reflected in the new title. Okay? Now, if the property was charged, number one, there are obligations of the buyer. There are obligations of the seller, the developer. The developer must send a notice. So the developer must send a notice to the purchaser. Okay? A notice of the charge, telling the developer, by the way, hii shamba nilikuwa nimechukua loan nayo ndio nijenge hii building unaona hapa, nimeteseka sana, nilichukua loan. Okay? Na hiyo loan nilichukua ya 20 million, nalipa kila month 100,000, interest ni 10%, na ni loan ya 5 years. Okay? Ni loan ya 5 years. That is all. So you have to send a notice of that charge to the purchaser. The notice will contain the following things. The first one, the principal amount of money that was loaned. What was the charged amount? The principal. What was the principal? Okay, that is the first one. The second one, the monthly installment or the installments payable. The second, that is the second one. The third one, you are going to have what you're calling the interest. What is the interest? And then the fourth one, you're going to have the term. What is the term? What is the term of the loan? The other one is the duration of amortization. If the loan is supposed to be amortized, what is the duration of amortization? Okay, amortization. So that is exactly what you send a notice. You have to send a notice plus the copy of the charge, notifying them so that they're not caught by surprise if the bank comes knocking. So you have to tell them that, by the way, watu wangu, ndio mpate hii nyumba yenye mnaona saa hii, mimi nimeteseka sana, ni loan nilikuwa nimeomba na hiyo loan imelipiwa hivi. So ni loan ya 10 million, monthly nalipa 200,000, interest ni 10%, na hii loan imechukua 5 years. Okay, so that is how the notice is supposed to look like. So you send out that notice. That is the first thing you need to understand about charges. If the property is charged, that's the second thing. The first thing is you must provide a copy of the charge. The second thing is you must send a notice to the purchasers of the information I've said. The principal amount, the monthly installment, the interest, the term, and then the amortization period, if it is there. Okay? Now, what is the last thing about charges you need to understand in as far as sectional properties is concerned? The question of discharge. So what happens to you as the person that is buying the property that was charged? Wewe umenunua tu apartment, hii story huko unajua. Does it mean that your property will also be charged? Your house will also be charged? Now, it is yes and it is no. Okay? So if you buy an apartment that was built on a land that was charged, initially, that title to the apartment is also charged. But once you pay the full purchase price, it is going to be discharged. Tuelewane hapo kidogo. Wenye nalala waamke wasikie hii maneno. Okay? Tunasema hivi. You take a loan. Bishar takes a loan. Okay? Bishar amechukua loan ya 100 million. Kujenga apartment yake vizuri. Apartment amejenga na amejenga 10 units. Okay? Amejenga 10 units. So apartment amejenga na ziko 10. Units are 10. Okay? Na kwa in the mind of Bishara anasema loan ni 100 million. So if I sell all these units, I should be able to get back and repay the loan. So Bishar cannot sell the units for anything less than 10 million. So atasema tu, out of my entire apartment, I mean, because my loan is 100 million, so 100 divided by 10. So each house is supposed to give me at least 10 million. Ndio nilipe loan ya 100 million na niko na manyumba 10, kila nyumba lazima inipee 10 million. So wewe ukikuja kununua nyumba kwa Bishara anakuambia hii nyumba nauza 10 million. Hiyo ingine 10 million. Okay? So it depends. Kama ni 1 bedroom, itakuwa maybe 10 million, 2 bedroom, 15 million. Hivyo. Tunaelewana? So the assumption is the purchase price of a house, once you pay the full purchase price of the house, you have paid your share of the charge. Then kama tumeelewana, tunasema kama loan ilikuwa 100 million na units are 10, the law assumes that that loan is distributed equally among all the units, so that wewe kama umenunua house number 1 na house number 1 is 10 million, ukilipa hiyo 10 million umemaliza, the law assumes ushalipa loan yako, part of the loan, because the loan ilichukuliwa na developer lazima ikuwe distributed in each house, so that when you pay the purchase price for the house, the law also assumes tayari umelipa deni yako pia ya hiyo charge. So what you do, you apply for a discharge. Okay? You apply for a discharge of your own house, of your house. So the bank will only discharge your house. The bank will only discharge your house. Unaelewana? So mtu mwingine pia akilipa yake amalize, aenda kwa bank ita discharge. Mtu mwingine pia akienda alipe. So that's what I'm saying. So it's called a partial discharge, or generally a discharge. So once you pay the full purchase price for that unit, ni kama ushalipa purchase price plus a loan. So nyumba yako itakuwa discharged. I have explained it in the language that I know best, and I hope that you understand that. That is the question of charges. That is the question of how to deal with charges. Any question up to there? Time is really running out. My time is actually out. So I will only take one question. Banafa. One question only. Banafa?
My question is with regards to what you've just concluded on. This scenario which happened, and there was this off-plan company, I think it's called Great Wall, and they built this. The apartments were called Great Wall Apartments, and in this case,
they are still called that. They are still called that. Did they change the name?
No. Okay, I'm not quite sure, but the issue is, why were these 100 unit owners threatened that the bank is going to repossess? Like, from what I've learned, if they had paid the purchase price, I mean, if they had paid the agreement to buy those, if they had paid the amount to get those units, then automatically there should have been, even if there was a charge, there should have been a partial discharge. However, that seems not to be the case, because the bank is ready to attach those selected units. So in such a scenario, what would have been the loophole?
It's a very simple thing. Ni wewe tu ukipewa fee na mzazi. Ukipewa fee na mzazi, uende ulipe KSL. Wewe unapitia tu, accounts zinakuwa gate B. Unatoka gate A, unapita gate B, unafika gate C. Unakunywa fee. And then KSL will send a notice to your parent and tell your parent that we want fee for this guy. But your parent will be saying, I paid the fees. I gave him the money. Doesn't matter. The same thing. If you pay and the landlord does not, the developer does not pay the bank doesn't care. The landlord didn't pay the bank. So if it goes to court, of course, if it goes to court, the court will stop the bank from selling a unit. Okay? The court will stop the bank from selling a unit. But the bank must threaten you that, hey, the landlord did not pay. Because when you pay, normally what happens is that the bank is supposed to enter into arrangement with the developer, so that all the money that is paid, you don't pay directly to the developer, you pay to the bank, and then the bank deducts their money. Okay, so deduct the money and then the discharge. But if you pay directly to the developer, then you really hope that the developer is a very responsible developer that will pay back the bank. Some developers will get the money, they will squander the money, they will disappear. And then ni nyinyi tu ma unit holders mtachwa hapo kumkiteseka na bank. So that is a very unfortunate scenario, but it happens, yes. You paid, the bank did not, the developer did not pay the bank. So in that instance, you can always go to court and have the court declare that your property not be discharged. No, I mean not be sold. The bank, of course, cannot sell your property if you've paid, but you'll also have to have evidence that you paid. Shalewana?
Yes, thank you.
All right, the corporation. The corporation now. Let's talk about the corporation quickly, guys. If you allow me, this is a two-class topic, but we are doing it in one because there's nothing really much. So if you allow me some few minutes, I will talk about the corporation and the termination of the cession of property. So in terms of the corporation, I've said the corporation will include everyone. Okay, the corporation will include everybody that buys a unit there. So all the unit holders will be the members of the corporation. They will be the members of the corporation. So every person that buys a unit there will automatically become a member of the corporation. Are we together? So the corporation is not a company. Guys, it is not a company. The corporation is not a company. It is a corporation formed under the Act. And this Act is the Cession of Properties Act. So that is the membership of the corporation. That is the membership of the corporation. The next thing you need to understand are the duties of the corporation. Okay, the duties. But before you go to the duties, you need to also understand the composition in terms of the structures of the corporation. So the first thing is the corporation will have a board of directors. Don't call them a board of directors. They'll have a board. Okay, they'll have a board. The management committee. It's called the management committee. Okay, now this management committee is picked from the members themselves. So wanasema hapana, huyu mtu wa house number 1, huyu ni wakili, tunamjua, anakaa mtu akona akili mzuri, tumweke hapo kwa board. Mtu mwingine anaishi huko juu top floor, pia ni daktari ama ni mtu wa security, anakaa mtu akona akili mzuri, tumweke kwa board. Huyu mwingine pia ni mwalimu, tumweke kwa board. So all of them ni watu tu wanajuana, they live in the same place. They pick themselves as members of the corporation, and then they make themselves the board. So they can say, remember the corporation will have the bylaws. So the bylaws will say that we will have a committee, a management committee of 10 people. Normally it is 7 to 15 people. So we'll have a corporation of 10 people that will be managing the property for 1 year, and then the next year we take another 10. It will be rotating like that. So that is upon them to decide. So the corporation will appoint the management committee that will be in charge of the day-to-day running of the corporation. Okay, things to do with paying rates, paying rent, paying insurance, paying the security, water, painting, all those things will be done by the management committee. Okay, the next thing is the disciplinary, the dispute resolutions committee. So within the corporation as well, they will also appoint a few people to form part of the dispute resolution committee. So this is the committee that is in charge of ensuring that the dispute is resolved. If there's any dispute between the members of the corporation, it is taken to the dispute resolution committee. Are you together? So those are the structures within within the corporation, and they're just picked from members, people that have bought units in that house, in that apartment or in that building, okay, or everyone that has a unit in that building. In terms of voting, 1 unit, 1 vote. If you have 2 units, you have 2 votes. Okay, so every unit is a vote. So the more number of units you have, the stronger your vote. Okay, so 1 unit, 1 vote. The next thing is the duties of the corporation. What are some of the duties of the corporation? Number 1, pay rates, pay rent, pay insurance premium, maintain a fund. They're supposed to maintain a fund, okay? Maintain a fund for the expenses. So they know that the expenses for the building could be the insurance, the rates, as well as other things to be paid, maybe security, water bills, and everything else. So they have to maintain a fund. Maintain a fund simply means that they collect the money. They have it somewhere, and then they use it in case they need it. So they maintain a fund for the expenses. Okay. They prepare the bylaws. Okay. Prepare the bylaws. They manage the common areas, management of the common areas, things like the parking and everything. They manage the common areas. We've also said they collect the service charge. That is part of the fund. They collect the service charge. Service charge is paid to them. They make sure the property is in good conditions. They maintain the property in good conditions. They receive service. Also, they defend a suit. They defend a suit on behalf of the members, as well as institute a suit on behalf of the members. Those are the duties of the corporation, really. Those are what the corporation will do. They pay rates, they pay rent, they pay the insurance premiums, they manage the property, the common areas, they do the repairs, and all that. They pay the utility bills such as the security, electricity, water, garbage collection. All that is the duty of the corporation. So they can also hire someone to do that for them. We have the real estate companies that do that. Okay. So you go and hire a company to be doing that. They will collect the money, they will pay everyone, so that you guys, as members of the corporation, you are busy professionals. You don't need to sit there and talk about garbage collection. You will hire a company to manage. We have management companies that do the management for people that don't want to take part in the day-to-day management of their own apartments. That is the corporation. And then, of course, let's talk about the termination of the section of properties. How is it terminated? Termination of the section of properties. How is it brought to an end? The first one is when the building is destroyed. Okay? When the building is destroyed by fire, flood, or any natural calamity. When the building is destroyed, the destruction of the building. The moment the building touches down, if the roof touches the floor, that is the end of the section of properties. Termination of the section of properties, the act of God, number 1. Number 2 is a unanimous decision. Okay? Members of the corporation can agree to sell or to dissolve the corporation, sell the building, divide the money and go their ways. Okay? A unanimous decision. The next one, or the next way in which the termination can happen, termination of the section of property, is through a compulsory acquisition of land. So if that land is compulsorily acquired by the government, then that corporation is terminated. So those are the 3 main ways in which, as not a corporation, but the section of property can be terminated. The first one is a unanimous decision, frustration, that is by an act of God, and when there is a compulsory acquisition of a building. And then I've said what happens after that. So if the building is destroyed, it means we revert back to the land. We go back to the land. So if the building is destroyed, all the new titles are cancelled. All of them are cancelled. Automatically, they are cancelled. All the new titles that were created, because they were created for building, for the units. The units have been destroyed. They're not there anymore. The only thing we have is just a bare land with the rocks on it. So all the titles are cancelled, and then you notify the registrar, and then the registrar will close the registers as well. And then the registrar will create a new title for the land that is remaining. Okay. And then, of course, how do you dispose that land? So how do you share the benefits? You can sell the land. Once you sell the land, you divide it according to the number of units you're having. If you sell the land at 3 million and you are 10 of you, each of you will have 1/10 times 3 million. Kila mtu apate share yake na aende. Because remember, you have what? You have a share. It is ownership in common. So you have a share. You have a share. You have a share. Okay? And then I also mentioned that the fact that when you buy a unit there, the register will indicate that you have a share. Your share will be indicated in the register. Your share of the property will be indicated in the register. How is it indicated? If the units are 50, then you will be told, the register will indicate that you own 1/50 of the common property. So every person will have 1/50 of the common property if you have one unit. If you have 2/50. That is 1 out of 25. Yeah. So that is 2/50 of the common properties. So the last thing I will mention quickly so that you can take questions is the question to do with renting. You can buy the unit and you rent it to someone else. Okay. You can buy the unit and you rent it to someone else. So if you're going to rent it to somebody else or lease it to someone else, you have to notify the corporation. You have to notify the corporation and tell them that wadau, mimi hii nyumba yangu nataka kupea mtu aishi hapa, juu mimi sitaki kuishi hapa. So you have to notify them, okay? But remember also, if this person violates the bylaws, he shall be chased without your consent. If you rent your unit that you bought to someone else and that somebody else does not adhere to the bylaws, the corporation will chase him away. Okay? The corporation will chase him away. Doesn't matter what kind of arrangement you've had with him, the corporation will chase him away from the property without even seeking your consent. Okay? Because the corporation is the management really. They will of course override you. Okay? And then of course, if you don't pay the service charge, if you don't pay any amount that is due to the corporation, if you're not paying garbage or anything else, the corporation is allowed to register a restriction, not really a caution. Sorry. The corporation will register a caution on your property, on that title. If you don't pay, you are supposed to pay the service charge and everything else, or any amount of money that you're supposed to pay. If you don't pay it, the members of the corporation or the corporation is allowed to lodge a caution against the title of your house, so that you don't deal in that house. You don't do anything with it until you pay. Okay, that is the end of section of properties. The only thing I want to mention is conversion. I will mention it as we go because it's the time for conversion was in 2022. That was the last time that it was allowed to be done. Right now, there's no conversion being done because it was up to 2022, which has passed. But I will mention conversion as we go. Now, I'm not very sure whether you guys are together, but if you have a question, put up your hand. We're done with section of properties, really. That is all about section of properties. So I welcome you to try and understand it deeply. Try and think about it genuinely so that everything is clear. Questions? Allah, mesikia, melewa? Hii beli ya leo sijui imetoka wapi? Hii beli ya leo nani imetoka wapi? I'm not very sure where you guys are from today. Nobody is saying anything. Hii beli si beli ya kawaida.
We are
Nani
busy right now.
anakasirisha hii? Okay, kama mko sawa, then we can join the class. I will share the recording if I'll share the recording later. If you guys are not saying anything. Anyone with
We
a
are
question?
digesting.
What are you digesting, Bana? Okay. Banafa, Abdul.
Mwalimu, when you're trying to distinguish between the corporation and the management company, which existed in the 1987 Act, apart from maybe the fact that one was formed under the Sectional Properties and the other the Companies Act, and the issue of filing returns, is there any other difference?
Thank you for bringing that one. Let me now, I was forgetting about the difference. I said I will give you the difference between subleases and sectional properties. Subleases and sectional properties. What are the differences? Sublease regime and sectional property regime. What is the differences? Okay. Now, for a sublease regime, number one, the mother title is not closed. The mother title is not closed. Okay. That is why it is a sublease regime. Okay. So sublease regime now, actually, let's not go to the mother title first. Okay. Let's not go to the mother title first. The first thing is that sublease regime only applies to leases. The property must be a lease. For there to be a sublease, the mother title must be a lease. While in sectional properties, both leases and freeholds. Okay? That is the first difference. The second difference is that when it comes to subleases, the mother title is not closed. The mother title is not closed. It is still active. The developer will have the mother title. The developer will have the mother title until he has sold the last unit. After he has sold the last unit, he will transfer the mother title to the management company. Okay? Now, in our sectional properties, the mother title is closed. The mother title is closed and new titles are created. Okay? So the mother title is closed under sectional properties. The third one is the mother title is closed in the second one. And the third difference is that we have subleases created from the mother title. So the mother title will give us subleases. Okay? So subleases, which are long-term leases, okay, will be created from the mother title. And those are the things that will be sold. Now, when it comes to this one, we have new certificate of leases, and certificate of titles being created. Okay. The fourth reason or the fourth difference is in the sublease, we don't have a corporation. We have a management company. In subleases, we have a management company. Okay. In sectional properties, we have a corporation. Okay. Now the management company is a company under the Act, which is the Companies Act. It is a company under the Companies Act. A corporation is not a company, or the corporation is not. This corporation is not a company. It is just a corporation that is formed under the Sectional Properties Act. Okay, so that is another difference between the management company and the SPA. Now, the fifth difference is that when it comes to the membership, every unit holder is given a share certificate, becomes a shareholder. Let me say like that. In subleases, every person that bought a unit under the sublease regime was given, or is given, was, because it is no longer existing, was given a share certificate. Why? They become shareholders in the company. Now, this is a companies under the Companies Act. Whatever we've discussed under companies in the commercial class will apply to this company here. So every person that buys a unit become a shareholder in the company. So depending, the number of shares you have will depend on the number of units. Okay? What you have the share certificate as shareholders having the share certificates. Okay? Now, when it comes to sectional properties, we don't have any shares. We don't have any shares. They just become members of the corporation with no shares. Are you together? So those are the main differences between subleases and sectional properties. Subleases and sectional properties. Though the sublease regime has been phased out, but it is also good that you understand how it works. So in the next class, I will talk something small about the sublease system, okay, and the conversion of the sublease system into the sectional properties in the next class. But those are the differences. Are you guys together? But we have discussed everything on sectional properties. You are ready to go and kill the exam. Okay, so guys, when somebody is telling you that they have a title, they want to construct apartments and sell them, and you are being told to discuss one of the ways in which they can structure this transaction, then it is the sectional properties. Okay, sectional properties. And you've said if it is a lease, it must be at least 21 years and above. Okay, if it is not 21 years and above, you cannot have a lease. You cannot have a sectional properties on a lease. Everything is clear? Any other question? Harris, what is it? Your microphone is unmuted. All right, then. I'm assuming, guys, you guys have not spoken in this class. You guys have refused to speak the whole time. It's sour. That is it, guys. I will stop recording so that we can go and rest because I think you guys are tired. I will stop the recording there. I will share the recording. Of course, guys, please ask for the recording now. Okay? Ask for the recording now. My wife will leave me and kids. My wife and the kids will leave me if I keep sending recordings all day. I don't even do anything else. Nataka bibi aniache na watoto. Please ask for the recording now. I also have a life. Nataka niachwe kama vile wewe pia uliachwa. Nataka tuachwe sisi wote. My friend, please ask for the recording now. Elizabeth, your hand is up.
It was by mistake, Pole.
Sawa. No pressure. So please ask. If you ask for it now, I'm able to send it when you wake up, whichever time you wake up. If you wake up at 1 or 2 or 3 or 4, you'll find it. But some of you are waiting until tomorrow. Okay? Don't do that. Thank you very much, guys. And next time, this bail is a very wrong bail. I don't want to see this bail in my class again. This one is crazy. You've not spoken in this class the whole time. But Nisawa. So I will stop the recording there and I will share it as I usually do. Please take time to go through the recording.